Happy Thursday and good evening, ladies and gentlemen. This is Reasonable Doubt, brought to you by the Harris County Criminal Lawyers Association, and I'm your host, Jimmy Ardwan, along with my co-host, Julio Vela. We're in the purple tie this evening.
Purple, stripe.
You got it going on.
You know, I'm feeling the groove, you know, just like, Thursday.
Like
yeah, sitting with my good friend here.
We got a great show for you tonight, ladies and gentlemen. We have on the program joining us one of the candidates, Democratic candidates for County Criminal Court at Law number 7, Andrew Wright. Andrew, or is it Grizzly Adams?
No, it's definitely Andrew. Definitely Andrew.
I was confused. I didn't know who showed up at first. But we welcome Andrew to the program for the next hour to talk with us about his campaign. We'll also talk about a couple current event issues going on that, hey, you know what? They actually involve some judges. So we'll get Andrew's perspective on that and how he might do if in a similar circumstance if he was the judge. But we'll be here for the next hour. 713-807-1794 is the number. We'll open up the phone lines about halfway through the program. We also have Twitter up at HCCLA_TV, so you can hit me up right here. So, Andrew,
yes,
how's your campaign going? Let's start there.
It's going, man. I mean, it's you sign up for something like that. It's a lot more work than you ever envisioned, but it's pretty neat meeting a whole bunch of different people that, if not put in that position, I wouldn't, I guess, be out there meeting. It's a lot of work. You know, away from home most nights, going to different campaign events, but it's pretty cool.
I'd like to bring up that I believe it's another full Longhorn show.
Is it really?
Yes, it is.
I didn't know you were.
Actually, Andrew and I went to school at the same time.
I think I was ahead of you, though, right? What year did you graduate?
05. 06. It took me 5 years to graduate.
So I was a year ahead of you. I was 04.
It took me 5 years, man.
Oh, you Julio boy.
Yeah, you know, the first year we called
Actually, I think it took
the freshman
7,
lap, right?
Yeah, it's a scratch. Hey, but you know what? I was in Texas, huh?
There you go.
Welcome.
So you talked about that you're meeting all these groups and you're meeting all these organizations. Is that what you had expected, or is it something that's actually more overwhelming than you thought?
I don't know what I expected, to be honest with you, man. I mean, you know that you've got different organizations that are important. So I'm running as a Democrat, so I'm going to a lot of the Democratic clubs and a lot of the I guess you could say organizations that would be kind of on that spectrum, right? So last night I was at the AFL-CIO. They were having candidates out to talk to some of their delegates for screening for the, we already screened, but for their endorsement. I got their endorsement today. So I mean, I expected some of that, but like just the magnitude. There's always, so when you file, you actually put your email address on there, and there will be people that will just shoot you emails about different organizations or different groups or different screenings and things like that. And it's like, I guess I didn't expect that.
Should have set up like a spam email for all this stuff.
I mean, the reality of it is, though, like a lot of them you want to engage with, right? Because otherwise, you know, you don't want to just sit there and sit on your thumbs and, you know, wait till March 6th shows up and then who knows.
I believe, isn't that what your primary opponent strategy is?
My primary opponent has not been to as many things as I would have expected, but I mean, everybody does their campaign their own way, so good luck to him. I hope he's not successful in March, but you know, the voters of Harris County will decide that.
And we invite him on the show. Come on the show. We sit down and talk. We have a good time. Let's talk about, so you went to the University of Texas.
Yes, sir, I did.
Out of law school.
Did you just call him sir?
Yes, sir.
Hey.
Call me sir? I mean, I realize I'm
trying.
So talk to us. And so you went to law school. Where'd you go to law school?
I went to law school here in Houston at South Texas College of Law. That's actually why I moved to Houston, and that would have been in 2004. Went to law school, graduated in 2007, worked for about a year and a half doing commercial litigation and employment defense litigation for a firm that I clerked for in law school, and left there the beginning of 2009 in that great legal market we had, and actually went out to work on my own. For some time I looked for jobs, and at a certain point I decided, you know what, let's just do this. And that's pretty much when I began. I wanted to do criminal law, but you know, it's kind of hard to go out on the ledge and start a new practice area. All I had known was commercial litigation, so started taking more clients. I'm pretty much to the point where that's almost all I do. I have a couple family law cases that are things that I just can't get rid of, or they're good friends or family or something like that. But Other than that, that's all I do is criminal law. That's what I do.
You're running for a county criminal court of law bench.
Yep.
What was the impetus behind you wanting to do criminal law first?
So I guess, so when I did commercial litigation, employment defense litigation, great people I worked for, but one of the things that really drove me crazy is we'd spend a lot of time either doing discovery and, pushing paper, I guess is what I'd call it. And we went to trial in that year and a half, maybe once, maybe twice, if I'm not mistaken. And that's really what I want to do. I want to do trial work. Now, I want to do criminal trial work, obviously, that's what I do, but trial is what I really enjoy. In fact, I was in trial in November, and at the end of November, beginning of December, in Fort Bend County. And as I was sitting there in that trial waiting for the jury to come back, all I kept thinking was, man, if this election thing works out, then I don't know if I'll be able to, I won't have this feeling for whoever knows how long that would be, right? It kind of drives me crazy because that's what I enjoy. There is some stuff about trial that I don't like, the nervousness, kind of like I have right now because this is my first time on TV. But once you get past it and you're actually in it, I love it. Nothing like it. I don't, I run or something like that, but I've never been into high pressure situations before that really put you to a test. And even, as criminal defense attorneys, we lose a good amount. But even the trials that you lose, you learn something, you at least gain some perspective, and especially if you have a client that is happy with your result, even if you technically didn't win, a lot of times, you did a good job. And keeping the government to their burden is what we're all about. And even if they get a conviction, they're going to work for it. And that's what I love. A lot.
What made you decide that you wanted to be a judge? And, why do you think you're qualified to be a judge at this point?
Okay, so, they teach us we're supposed to do this elevator speech, pitch, or whatever for when people ask us these type of questions, right?
Kind of like the why do you do criminal defense law?
Yeah, yeah, which mine is never as short as I guess it's supposed to be, right? So I think the thing that really bothered me, I'm at the criminal courthouse almost every day. I do practice in Fort Bend County and Galveston County as well, but I'm down at the criminal courthouse, now the Family Law Center after Harvey, thanks a lot. But the thing that really has been bothering me is, we'll call it the plea mill, we'll call it the bail bond situation. There's a whole different host of ways we can reference it, but the way that we do bail in Harris County is not right. Okay, the people that have brought that bail lawsuit, bail reform lawsuit, they're big to me in my heart, because at the end of the day, we have people sitting in the jail that will plead guilty. Sometimes because they are guilty, sometimes they're not. I don't know, but they'll plead guilty because they got to go to work, or they got a car that's in impound, or they've got a job that they're going to lose if they miss too many days. And I saw our current slate of judges opposing that system. Now, they say they're going to do reform on their own way, but I would ask you if they would even do anything if this hadn't been brought to their doorstep, okay? And then, as a taxpayer, we're spending $5 million defending a broken system.
Well, it's going to be more than that.
Well, it's $5 million now.
It's $5 million now, so and we just had another hearing this week that we could talk about.
And how much of that money could have been put towards indigent defense, could have been put towards rehabilitative programs or diversion programs that keep those people out. And let's be realistic. People that are on bond have a lot wider range of options, okay? And we're talking about misdemeanors here. It's kind of like when Alan Iverson was like, we're talking about practice. We're talking about misdemeanors. Like, they're criminal offenses, yes, but is that something that should derail a person's whole life? Okay? And that really is the main reason that I'm running. I also think that certain courts, those judges have been there a while and they've lost some perspective. And I have seen certain judges treat defendants that come before them with not as much respect as I would hope that would be shown. Because no matter what they're charged with, what their criminal history is, we've all seen clients with criminal history that could go down my arm. But it's still a person, and they're still should be given amount of respect that I have not, that sometimes I don't see. I won't say I have not seen. There are plenty of judges that do, but I mean, come on. There's also prosecutors that drive me crazy. So I think one of the reasons I'm running is I think that some of that change that I can try to do on a case-by-case basis, hopefully if elected, we can help, or I can help enact some change. Getting people out of the criminal justice system is a good thing that needs to be done.
You talked about bail,
Yes, sir.
and these kind of things, but let me play devil's advocate here.
Yes, sir.
I mean, don't they put themselves in this position? I mean, aren't they the ones that are out there trespassing or DWIing or doing drugs? And why? So why should you give them an unsecured bond or a personal recognizance bond if they continue to do these things?
Excuse me. So some of those are a little bit different, right? So DWIs kind of run the gamut of people charged with them, right? But let's talk about things like criminal trespass, right? I would tender to you, and I don't know the statistics, I would bet you really good money in Harris County, the vast majority of people charged with criminal trespass in Harris County are homeless people, okay? Let's work on getting some resources to get those people in a place that hopefully they can start to rebuild their life, right? I will give you that there's a percentage of the homeless population that does not want that, but there's a lot of those folks that are out there. There's some about a mile from here that are run by probably 3 times a week. I live in the neighborhood, right? And I guarantee you a lot of them, if they had a little bit of help, probably would be somewhere else, okay? So why are we going to continue to arrest somebody and lock them up and spend all of our tax dollars when we can divert those funds and get them a better situation? And I don't know how it's done. I'm not a judge, okay? I'm running for one, and I'm sure once you get on the bench, there's a lot of different inner workings and a lot of different things at play. But spending $5 million to keep these people locked up is offensive. Spending even more money to continue to get their bond revoked and then go rearrest them and then hold them here. We're shipping people to Louisiana and Newton County just to house inmates. Okay?
Do you think that if one gets released on a PR bond, that they should be continually, and if they continue to pick up charges or accusations, and like I said, I'm playing devil's advocate.
Right.
Should they be given unsecured bonds, or what's your stance on that?
Yeah, and that's something I struggle with, right? Because you and I both do criminal appointments at the courthouse, right? And we have both seen people that will just keep coming back. They'll get an unsecured bond and they come back. There's got to be a certain point that a magistrate or a judge has to look at it and say, okay, this stops, right? But I don't know at what point it is. I think there's a case-by-case scenario, which I can't just tell you, like, hey, if they've got 2, they're out, right? Or they've got 3. Like, I think I was watching the program a couple weeks ago. You had a guy that came back, 5-6 times with all criminal trespasses. I mean, there's a certain point that becomes crazy, right? Because then that guy's just going to have 6 warrants out, and then he's going to keep coming back. So I don't know what the breaking point is. But I don't think that what we're doing right now is, or at least a year ago, is what the right answer is. And, these judges right now are complaining about bond forfeiture rates, right? What are they saying? It's like 45%. I think the numbers are more like 43%, okay, of the unsecured bond forfeitures. I'd like to see the numbers, and maybe I need to talk to the clerk's office before that, because I don't think it's drastically higher, okay? 2 years ago, I've sat through dockets and seen a lot of bond forfeitures. That's just the nature of our business, okay? Unfortunately, there's a lot of people that wouldn't be in the criminal justice system if they were on top of their stuff and getting where they need to be when they need to be, okay? Well, let's work on helping them. Let's not make their situation worse.
I mean, I think the problem is, though, and I hear what you're saying, and I hear the arguments in the bail bond reform lawsuit, but the problem to me is, okay, maybe you do have homeless people getting charged with the majority of the trespassing cases. I have no doubt that that's probably true.
Yes, sir.
But that's probably also a fraction of the 20,000 misdemeanor cases or whatever they are that are filed in Harris County every year. So that was the point I made last week with Lori on the program, is that when we're talking about bail bonds reform, Everybody wants to go, both sides, and both sides are guilty of this, okay? Because they want to go, or we talk about probation reform or whatever, any kind of reform. Both sides, and this is where we're at with the country right now, we go to the most extreme.
Yep.
It's unfortunate because the left wants to say, you're putting all these homeless people who are committing trespasses, you're holding them in jail and not allowing them to, really defend their case, and you're just warehousing them. Well, okay, yes, but that's a societal problem that we have, okay?
Yes, sir.
Because the reality is, if I'm a business owner or if I'm a property owner, I don't want homeless people camping out on my front door. I don't want them camping out in front of my building. If I've got a law office on Main Street and I've got a homeless guy sitting laying on the front door
Right.
on cardboard, smelling like urine, smelling like feces, doing his business right there on my doorstep, and my clients have to come over that's not good for my business. So yes, he is trespassing. I'm sorry that he's homeless, but
Right.
you know what? You got to get out of here. And the only way to get him out of there is to have the cops. The flip side of that is the conservatives want to go and say, well, I'm not comfortable letting these people out because I don't want them to go out and, while they're on bond for trespassing and go and commit murder. They always go to go and commit murder, So there's got to be a middle ground here. We've gone to the polls on, the extreme polls on both sides. And that's the problem is we're not finding a compromise situation here. And there's got to be a compromise. I mean, you don't have to, the reality is with a bond, if
Right.
you've got somebody who's a professional or a business person, they're charged with DWI, it doesn't matter if they can afford the bond or you give them a PR bond, that person's going to come to court. That person is probably going to do whatever you tell them because it's important to them, because
Right.
they now realize like, oh crap, I've basically shot myself in the foot potentially from a professional standpoint, from a career advancement standpoint, from a societal standpoint, because I could be tattooed with this DWI the rest of my life.
Correct.
Whereas you have another segment, they don't give a rip. So what? I was charged with DWI. I'm just going to go right back out to the bar and drink again. That happens, okay?
Right.
But you can't shoehorn everybody into one system. And you can't just go to the polls and say, go to the most extremes and say, well, this is what we've got here. You need to come to our side, or you need to come to our side. We got to have a compromise here.
And
so how do we do that?
And I agree with you because, like I say, the person that's a proverbial trespasser or any of those misdemeanors that keep coming back, we don't need to keep giving them PR bonds. I mean, there's a certain point that enough's enough. Because you're right. Because the guy that's on your doorstep on Main that's going to continue. We arrest him 8 times, it's probably not going to change.
I mean, they're showering in the fountains outside the Harris County Administrative Building, taking a bath out there.
Haven't seen that one.
Oh,
I've seen it.
I've seen it.
I've seen it.
I'm not denying it. I mean, I've seen showering in different places, but not there.
I don't want to see that. If I bring my kids downtown, I don't want to have some naked homeless dude in the fountain outside the Harris County Administrative Building when I'm just trying to go to the Honeymoon Cafe to have a cup of coffee and a pastry with my kids.
They're really expensive.
They're
good though.
They're very great sandwiches. Super expensive.
I don't want to see that. I don't want my kids to see that. So what are you going to do? Because you let them out on PR bonds, they're just going to go right back to doing that.
And you're going to be able to deal with that kind of pressure if you sit there. I mean, you're going to. I mean, because.
I mean, that's the job, right? So you got to. And I'm trying to think of a perfect answer to Jimmy's.
There is no perfect answer.
There's not. There's not.
That's the problem is there's no perfect answer. And it stumps everybody when I put it that way, because the reality is what needs to happen is we need to find a compromise solution. We need to find a way to say, and this goes back to what happened this week in court. We need to be able to let the magistrates decide,
do their job,
and actually act as judges and not have mandates coming down from supposedly. Now, I mean, look, we'll see what the evidence shows. But
whoever's above them.
I heard it was the district court's fault.
Well, they're pointing fingers.
They're doing this. They're doing this.
One sent as a district court, one sent as a county court. Apparently, Eric Hagstedt went in and testified, and we'll see. Well, apparently, they're going to get all the testimony and the evidence, but from what I understand, according to the paper, he testified at the State Judicial Conduct Commission that it was both the district and county. Now, I don't know what the evidence is. We'll see what it shows. But
well, I didn't know that the requests were not limited in scope. So I didn't know they wanted all the information from all the years ago. It's what I kind of heard them arguing. I'm sitting there like, seriously? It's like going to the judge and saying, it was mouthwash, Judge. Like, nobody bought that.
Yeah.
Nobody bought that argument. Are you serious?
Yeah.
I had some Wonder Bread. And,
it's like,
blew on my interlock.
I didn't know the requests were that broad in scope, and that's what actually you were asking us for, Judge.
Well, have you ever done civil work?
Once.
Okay, so civil discovery is throwing a big old net out there, right, and hoping you're catching some nuggets down there. So
and hoping the judge lets you get all
right,
of it, too.
right. I hope nobody, comes in and objects or moves to quash or whatever, right? So we're paying lawyers some really big money, and then the lawyers on the plaintiff side are some really sophisticated lawyers at Sussman Godfrey. So none of these people are new to that game. So it doesn't surprise me one bit saying somebody, I didn't realize it was that overbroad, or that, broad, and I was just trying to give you what you asked for. I didn't realize you asked for this. It's going to be real interesting to see what happens. I don't think you'll get a perfect right answer because I don't think I don't think those emails exist.
Let me.
Well, and the problem is the injunction has really thrown everything for a loop.
Yeah.
I mean, the system we have, or the injunction that we're operating under, quite frankly, has put everything into a very problematic state, in my opinion. Because what do you do? I had this issue just come up this week. What do you do if a PR bond is set? Okay, DA indicts your client, but is recommending a PR bond. Okay, where do we go? What do we do? The DA's response? I don't know. I have no clue.
Oh, yeah, they're never going to answer that.
You call pretrial services, they're like, I guess you can come down here to 49 San Jacinto, and we'll evaluate you.
Yeah, we'll give.
And then we'll walk you over to court.
Let you get arrested.
And let you do that. And then, then you go talk to the judge about it, and the judge says, well, no, they've got to get evaluated. They just can't come over here and sign. Well, we can't print the bond paperwork out. So it's like, so we've got this mess. And so functionally I see it's working, but even if the DA is recommending a PR bond, you still have to get arrested and processed and spend 24 to 48 hours in jail. I mean, that defeats the whole purpose of a PR bond.
Yeah, and they claim that it's cut down processing times in the jail. It has not cut down processing times. Like, I don't know what it is about that vortex of getting out of jail. I've had friends, clients, all sorts of people I know.
Shift change,
yeah,
whatever.
And you're talking 20 hours from that bond's posted, and it hasn't gotten any better. I would have hoped it would have.
Allow me to ask this question.
Yes, sir.
First, he doesn't have to allow you to do anything. You just do it. He's the guest.
Have seen, since the lawsuit, I have seen county judges implement reforms. And I'm getting PR bonds, okay? Our clients are getting PR bonds.
Right.
My clients are getting unsecured bonds, they're getting PR bonds. The county judges are, for the most part, following through with the orders, okay? They are.
Yeah.
And the problem, while not perfectly remedied and not perfectly fixed,
Right.
has turned. It has changed. We are getting PR bonds. They're getting PR bonds. They're getting unsecured bonds. So, with that being said, what more is there to do past this injunction?
Well,
right? I mean, what is there to do? What is there to do left?
Well, the injunction is just, a temporary, essentially, court order, right? So theoretically, it would go to trial, and then Judge Rosenthal would, I don't know, and I don't know enough about federal work. This guy probably does, but I don't know if that's a jury type issue or if that's all the judge. But I mean, essentially, she could implement final orders that are binding forever. So theoretically, this case goes away. Assume the plaintiff non-suits tomorrow, the injunction's gone.
And there'd be some sort of consent decree that's entered?
The injunction would be gone. I don't think there would be any authority for Judge Rosenthal to do anything to these parties.
And so I have to look procedurally, but I mean, I believe it's a temporary injunction while they're waiting. And so they would then have a permanent injunction hearing, at which point whatever the judge decides would be the final order. I mean, she could, just because the permanent injunction says they have to operate this way, once she could flip it, she could add to it. So when it comes to the permanent injunction could look very different. And that's what would stay in place until we get to trial in this thing.
Subject to appellate review.
Right.
I'm sure that as much money as they've spent on it, as far as they've taken, I'm sure that the county would deal with it all the way up.
Yeah.
Part two to the question. We talk about the county spending $5 million, $6 million in defending this lawsuit.
Yes, sir.
Do we think that the lawyers for the plaintiffs aren't going to ask for attorney's fees on the back end?
They are.
So are we talking about the county not only paying for the 5 or 6 or 8 million by the time it's done of fees in defending it, but then also paying the plaintiffs another 5 or 6 or 8 million dollars in pursuing this?
Possible.
Well, so they have I think it's one lady, if not more than one, that is essentially the plaintiff that's bringing this lawsuit. She I think had a DWI offense.
Yes.
Pled to get out and then filed the lawsuit, right? So
She had a $2,500 bond too.
Is that what it
settled with
was?
DWLI, yeah.
So she essentially, I guess, if successful, could get a money judgment from the county, and I'm sure Sussman Godfrey, who is probably doing it right now for free, would love to get paid.
Well, that's the biggest thing. They're saying that, Sussman, they're doing this for pro bono and all these kind of things.
No. I believe they filed as a 1983 claim, and so you're entitled to attorney's fees if you prevail in a 1983 action.
Wow.
And those attorney's fees can't be cheap for that firm. No. They're a big shop. They're really smart and they know what they're doing. And I'm sure they're going to want to get made as whole as they can. And that's going to come out of John Q. taxpayers' pocket, theoretically.
So question 3, is Sussman and Godfrey going to donate all the attorney's fees that they win back to indigent defense?
You'd have to talk to Steve Sussman for that question, and I don't think he's coming on the show. So.
Oh, wow.
We're getting close enough. If you guys want to call in, 713-807-1794, we'll go ahead and open up the phone lines for your calls. Also, hit us up on Twitter at HCCLA_TV. Andrew, I want to go back to something you said earlier, and that was one of the reasons you wanted to run for judge was because you saw some of the current judiciary not treating defendants with respect.
Yes, sir.
This week, we saw the sentencing of Larry Nassar up in Michigan, Dr. Larry Nassar,
Yes,
for sexually abusing many of the members of the USA Gymnastics and several other young women. And what we saw was the state proceeding up in Michigan, where they allowed 156 victims come and testify, and the
I thought
judge.
it was federal, wasn't it federal?
So that's part of what I want to get to is first he had his federal sentence, which he got 60 years federally.
Right.
And then he went to be sentenced by the state court judge. So of course we saw this, and there's been a lot of debate both on Twitter and on Facebook about that judge's actions, the way she was doing, the comments, the throwing of his letter that he wrote to her. I signed your death warrant. It's an honor to be able to sentence you. Some of the comments that she made about if I could, we don't allow cruel and unusual punishment. But if I could, I would let multiple people sexually abuse you the way you sexually abused.
I didn't hear that.
I didn't hear that.
That one was out there too.
Okay.
And so there was this debate on both sides that a lot of people, including a lot of lawyers, felt she was over the top, that she was just drawing a lot of attention to herself by allowing this many victims to testify, by televising it, by the things she said. And a lot of other people were like, no, she has the absolute right to do that. He's pled guilty. She at that point she loses her neutral arbiter hat.
Right.
For me, I kind of see both sides of it.
I do too.
And I do think that a judge, once somebody has pled guilty, all bets are off. Okay.
Right.
At that point, I'm not sure that, and I've been there. I mean, I've seen a lot of judges say things to my clients that you're like, ugh, this is uncomfortable. And it happens. But at the same time, what I didn't like about her was not what she said. Because frankly, I agree with some of the words she said. What he did to those women,
Inexcusable. Terrible.
And I kind of frankly agree with hey, if I could, I'd sentence you to get sexually molested by a bunch of people. I mean, part of me is like, I agree with that. What I don't agree with, though, is the level of attention and kind of her attitude, the throwing of the theatrics of the whole thing, almost as if she was trying to audition to be the next Judge Judy or something like that. And so I wanted to get your thoughts on that because, you know, if you get to become a judge, you're going to have to sentence people.
Right.
Sentence people who have pled guilty. Sentence people who have lost at trial.
Yes, sir.
And everybody you talk to, whether it's a federal judge or a state court judge, they all say that sentencing is sometimes the hardest part of the job.
Right.
And so I want to get your thoughts on what happened in Michigan and what you mean by respect for defendants.
So the Michigan thing kind of, you know, I look at it with two hats. I'm a criminal defense attorney, right? And then I'm also a person that's running to be a candidate and hopefully a judge one day. As a defense attorney, if that was my client, I'd be really upset. But at the same time, I'm not too thrilled if I was to be a fellow judge for somebody making those type of comments. This guy pled guilty to some really monstrous, really terrible stuff for like 30 years. But at the same time, your job is to carry out what you think is an appropriate sentence, right? But all the extra stuff, I don't think, I'm not comfortable with that, I guess is lack of a better term. I'm trying to find a nicer way to put it. But, you know, I thought it was a little crazy, the letter that he wrote. Like, I've had clients file pro se stuff, and I kind of look at it, and I probably feel a little bit like, depending on what it says, a lot of times they say my lawyer's not coming to see me, and I go see him pretty often, right? But I don't know why all that was done in the way it was. I feel like she was probably trying to go way to the other side because of how many victims and what all was involved. I mean, it's I guess absent murder, that's probably as serious as the type of offenses as we have, and it spanned, what, 160 some odd victims or so?
I would argue that's worse than murder. I frankly would, because
right, because they live
honestly, with murder, your victim's dead. They're not enduring the pain for the rest of
their life.
And so I would argue that this is actually worse than murder.
Yeah, it's arguable. I mean, and I can see your point, and I'm not necessarily disagreeing with you, right? But but her doing all that other stuff, I'm not comfortable with.
Yeah.
I think now let's be realistic. I'm running for a criminal county court at law bench, right? The largest offense, well, I guess it depends on what you consider to be more serious, is like your DWI seconds, your domestic violences, burglary, motor vehicle, the capital misdemeanor, right? But so the most anybody could get is up to a year, right? Yeah. So I don't think if I were to be on that bench, that I'm going to be anywhere near that position, right? At some point, somebody close to me had tried to get me to consider doing a district court bench, which is a felony bench, as we all know.
Yeah.
I'm not really comfortable with something like that for the simple fact of, one, I've only been licensed 10 years, okay? So I think people that are taking those heavy hitter jobs should be in the trenches a long time, whether they be a prosecutor or a defense attorney or both, right? And frankly, I'm not comfortable with, potentially sentencing somebody to the rest of their life.
How about death?
I couldn't even begin to tell you the gravitas that would be put on a person to make that type of decision, or potentially, even if it's already been decided, signing somebody's death warrant.
Right.
Right? You're, in a sense, with a pen taking somebody's life, and that makes me very nervous. Okay? So I think when you're sentencing somebody, I don't even know how much of those statements a judge should make. I think the judge can have their reasons. Maybe the judge is really incensed, and I'm going to give you 40 to 175 years because you're the most evil thing I've ever seen in my courtroom. But all the extra is unnecessary. Look, the victims can go do that. They can make a victim impact statement, all that type of stuff. But as far as piling on, unless maybe she's going for votes or something, I don't see the point of that. And I honestly think that some people probably would feel like that went outside the judicial canon of ethics.
I would hate to take the next sexual assault case in her court.
Yeah.
Yeah. Well, and frankly, she's just factually inaccurate because she didn't sign his death warrant because the federal judge actually did that when he gave him 60.
Right.
And he's in his mid-50s, right?
Yeah, that was the death warrant right there.
I'm not okay with all that. I'm not that judge. I'm not in that seat. But at the same time, it's like, just do your job. Go to work. Do your job. You can do it without all that extra, I guess we'll call it theatrics for lack of a better term. don't get me wrong, I'm not saying this guy was a sweetheart or anything like that, and what he did. I mean, I listen to the news when I'm going to different courthouses, and just it's crazy. It's crazy and evil what was done.
And I don't want to put you on the spot, because certainly I think it's not a proper question to ask you what you would do in a given situation. I think it's completely inappropriate. But some of the concerns, obviously, that defense lawyers have when they appear in front of a judge is deciding whether to advise a client on a plea deal or to plead guilty to the judge rather than take the state's deal, or even, should we go ahead and roll the dice and try the case?
Yes,
because what is the judge going to do? And then, do we do judge sentencing or jury sentencing? And even if we do jury sentencing, the judge still has the option to tax him,
that sentence,
to tack jail time as a
or do the
condition
conditions,
and so I think, and I'm not asking you to obviously say what you would do in a given situation, but I mean, those are some of the things that you're going to have to decide what to do. And you're going to have to, those of us who practice before you, if you become a judge, are going to have to kind of figure out, like, what the hell is he going to do in this situation? What makes him tick? What really gets him? What aggravates him? What doesn't aggravate him? I mean, that's kind of what we all have to do. And so, I think that's a challenge for everybody, because obviously you want to make sure that people feel comfortable in approaching you as the judge, but you also don't want to
think you're a pushover or anything like that.
Right, or put yourself in an ethically compromising situation.
As a practicing lawyer in those courts, one of the things that really drives me crazy is we know them as busted plea bargains, right? Mm-hmm. You're a prosecutor, you're a defense attorney, you guys come to an agreement, go up to the bench, and sometimes we even have to do that whole preview conversation, right? Just to see if the judge is going to flip. So if they do, we're going to go back and talk about it, come up with something else. That drives me crazy, okay? As a judge, if he's the, I don't remember who I told was who, but let's assume he's the prosecutor, right?
You got it right the first time.
He's going to know what's in this case, right? He's going to know that case, hopefully, I would hope, and this is wishful thinking to some degree, right? He's going to know what the good, the bad, and the ugly is, and what that case is really worth, right? And you're the defense attorney. You're going to know the mitigating factors related to your client, the things that show that, like, hey, maybe something like this happened, but there's other stuff to it. Certain judges, and I'm not even talking about a specific one when I say this, certain judges have like a rule. I won't do more than 60 days on a DWI second, right? So don't come to me with anything less than that. But let's assume he's the prosecutor with a DWI second. Maybe the first one was 30 years ago, and he's like, this is worth 30 days, and you guys agreed to it.
Or I got a weak case.
Whatever it is.
Yeah.
Why would I intermingle with that? Because at the end of the day, and I think these judges, some of the judges, I think, feel like it's they have to be accountable to voters, and they feel like they don't want to look soft on crime. But that's not on me. That's on him. Okay? So I just.
Well, but aren't you the but I would.
You're the gatekeeper?
The gatekeeper argument. The checks and balances of the system. I mean, how we have Congress and we have the House and we have the executive and the judicial and the legislative, and I mean, it's we have checks and balances. So I'm not sure that I necessarily have a problem with a judge that if something doesn't pass the smell test, they say,
no.
I'm not sure I have a problem with that. I mean, the legislature has said, look, the judges have the check on this. And, what's to say? I realize that maybe 99% of the time, let's say, 99.9% of the time, maybe we're doing the right thing. Maybe we're trying to do the right thing, and we're trying to explain and get the right deal. But there is probably occasionally where it's I'm going to look the other way because this is my friend, he's a defense lawyer. And I'm not saying that's the norm, but that happens. We all know that happens, where somebody can cut a really good deal
because of who you are.
Because of who you are or the relationships you have or whatever. And I really don't have a problem if something doesn't feel right with the judge to be able to say, you know what, no. Something's not right about this.
Yeah, but that's on a case-by-case basis, right? I'm talking about just like a
blanket
flat line
policy
rule. Yeah, I'm not going to take anything less than 180 days on a BMV or something like that. I've ran into that in the last couple months. And it's like, maybe there's a reason that 180 days for that particular person or less than, might be appropriate, right? Maybe it's their, second BMV, but they have 30 other misdemeanor convictions, so maybe 180 days isn't it? I don't know, right? Like, I won't know until if I get elected and I'm on the bench what's appropriate, right? Which is hopefully why those questions are asked. But we have all been in courtrooms where a certain judge won't do anything other than that. There's a judge in Galveston that won't do probation on certain felony offenses. The code doesn't say that, but they won't do it. And that grinds my gear.
Well, look, I've had cases where the judge wouldn't approve deferred because we couldn't come up with full restitution, or
It seems like you're not being able to consider the full range of punishment, and it seems like that those policies actually have constitutional implications.
Well, I would agree.
Let me ask you this. So going back
on, it's a plea deal. So I don't agree with you on that, because at that point it's a plea deal. They're not saying they can't consider the full range of punishment. They're just saying, look, I'm not comfortable with that deal you're bringing me.
Well, rejecting it. Going back on what Andrew was saying, there's some judges that say I'm not going to consider less than 90 days on this case, on these types of cases. Period.
Yeah.
I think that when we run into those scenarios,
that's a different scenario.
So let me piggyback off judicial involvement, right? Okay. So this is a question we've asked all the candidates that have been on the show so far.
Yes, sir.
What do you believe the judge's role is in pretrial interventions or pretrial diversions? Keeping in mind with that, if you're going to keep someone on bond, for example, and you're going to be using pretrial services or resources for them, do you think it's appropriate to say in these types of cases, on a case-by-case basis, you're not going to approve or deny pretrial intervention? Or what's your general stance or feelings on judicial involvement in pretrial interventions or diversions?
I think it should be very limited, okay? I don't think the judges should really be the one that decides whether or not somebody goes on pretrial intervention or not. I think that's a prosecutor. I think, kind of like going back to the plea bargain thing, if the DA's taken a good look at it and they've decided that they're going to extend a pretrial intervention, why not? Okay? Now, if there's a problem along the way, then I think the judge might decide, okay, look, this person was on a DWI intervention and they keep blowing into their interlock and they can't stop drinking, so maybe we need to not give them any more time to be on that intervention because there's been problems, right? But, I think that's what you're talking about to some degree. But as far as I'm not going to allow that person to be on pretrial because of it's a DWI with an accident, or if it's over 0.15 or something like that, I don't understand that, okay? Especially, I think judges are worried about their docket numbers, and that doesn't make sense. They don't want it to sit on their docket. What's the issue? You have a job to do, okay? If you have 0 cases on your docket tomorrow, you should probably still be at court and be there to deal with stuff, right? So I've heard judges complain about lengths of interventions, which I think is now why we're in Harris County seeing like 6-month interventions, which 5 years ago you weren't seeing anything less than a year, right? I don't think judges should be that involved with it, okay? Unless there's a problem and it's like, why is this hanging out in my docket? Because, not that, I take that back. Why am I continuously getting these reports, like interlock, or they're not doing the community supervision or something like that? Mm-hmm. I don't really like judicial involvement in micromanaging my cases. In general, as a defense attorney, it kind of drives me crazy. You need to approach before you reset that case. Well, judge, this is what's going on. Prosecutor's on board. Well, I don't know if I'm comfortable with resetting it that far.
Well, let's talk about another role of when you're running a courtroom is dockets.
Yes, sir.
Do you got a plan on how you're going to run your docket?
So I've thought about that, and I've seen the show, and I know y'all have discussed that, and it's something that I've been kicking around my head. I don't know if something like a scheduling order is the way to go, but I think that I don't think people need to go down to the courthouse every setting and let Jimmy or myself or you work and sit there for 3 hours while they get reset. So I don't know if I'm going to have a hard and fast rule like some of the other candidates I've heard, but I'm going to really look at ways to limit people going down to the courthouse. Okay? I was walking to the courthouse on Monday, and I heard this young couple walking with their 18-month-old, and I was hearing them talk about how they couldn't get a babysitter, so they had to bring the baby, right? I don't know what that person was going to do, but if they were dealing with all that strife just to go sit in a courtroom, for the lawyer to show up, the lawyer to work and find out if the discovery or the evidence or whatever is in, and then to get reset again, that's kind of crazy, okay? Especially now that we're in post-Harvey limited courthouse space, okay? These people have enough external pressures on them to resolve their cases with their jobs, their families, and things like that. We don't need to add to it. And what I'm talking about misdemeanor land. Felony land is a whole different ballgame, right? But making people show up every time, or if they're 5 minutes late or something like that, is more micromanaging than I think we need at that courthouse.
Well, I mean, so you say good things, but how is that actually going to be rolled out in a sense of?
So have you handled any cases in Austin?
I have.
Okay.
Yeah.
So some of the misdemeanor courts there, the lawyer, excuse me, the lawyer is the only person that needs to show up until like the final pretrial conference, right?
Mm-hmm. And you can do it by phone too.
Sometimes you can, and I've never had an issue with any case I've had in Austin getting taken care of. And when the client needs to be there, hey, show up in court. Okay? So maybe we waive appearances to some degree, or I don't know if you could say in all, because I get really nervous saying about like broad line, all or everybody or anything like that. But I mean, why have a person come sit down there for 3 hours, get reset, and then they get frustrated and they're like, man, I just want to plead because I don't want to keep coming down here.
Lori brought up a good point last week saying that if we're going to talk about their case, they got to be there.
So how often do you talk to your clients? A lot, right?
Yeah.
So your client that calls you and talks to you about his case, he knows what's going on, right?
He does.
Okay. So why does he need to be there when you're waiting on blood discovery? Why does he need to be there if you're waiting on the DA's office to get you a video? That your client sitting there does not add any pressure to that DA to get that video in, does it?
No.
No, because they've got hundreds of other files that they're going to be at as soon as they're done with that docket, right? So I don't agree with that.
Huh.
And Lori and I are friends, and we have different views on things. You know, she's got her opinions to how she will run her docket if she gets on a bench, and I've got different opinions.
Strong.
It is
That's
strong.
strong. So, okay, the other question we've asked is the assault family member cases. You
Yes,
know,
sir.
the MOEPs and no contact orders. What's your feeling? Obviously, case by case basis, but what's your stance on those? What's your positions on MOEPs before talking to complaining witnesses or no context in these things?
I want to know if the complainant has been talked to first would be the first thing I think about, because I had a case in December where my client was out on a 2B warrant that was a warrant that had been issued for a domestic violence case, right? My client, and that warrant had been out for a couple months. My client and his wife had talked. He actually left the house for a couple days while things cooled off. And then she said, hey, if you want to come home, you need to do this. He enrolled in an anger management course on his own. He started going to counseling with an anger management counselor. They were doing couples counseling. They were doing a lot of stuff. And after about a month, he came home, and they've been doing a lot better. He's dealing with some employment issues, which I think added to some frustrations he had, and he kind of bowled over, okay? So I got hired, and I went to go resolve that warrant. We all know that you will have to show up to court most of the time, like we were talking about earlier. You have to show up in court, present yourself, get the judge to let you, because it was a no bond because of these MOEP issues, right, and no contacts. So I had from the complainant notarized affidavit saying, because she told me she wanted him to be able to stay at home. I had a notarized affidavit saying I don't want a no contact, I don't want a MOEP, I don't want any of those things. Showed up in court, explained it to the judge, gave the prosecutor her phone number, said please call her. They had a little one at home that she could not get a babysitter, and they had two other ones that are 5 and 6, I think, and then a real little one, okay? This judge decided that she was going to put a mow up where he couldn't be at the house. And I spent probably 20 minutes at the bench explaining to this judge why that was not appropriate in this case. I even told the judge, hey, if you want to call the complainant from the bench, please be my guest. Here's her phone number. That didn't happen. She entered the judge entered the mow-up, okay, and my client could not go home that day. Now, they had 3 young kids that, part of their family dynamic was he helped her a lot around the house. So I actually had to call the complainant and tell her, hey, he's not coming home and here's why. I had to wait till, I think, the following Monday or Tuesday till I could get her in there, and then I finally was able to get the judge to lift the mow-up, no, she put a no contact, I apologize. She ended up lifting the no contact and then put a mow-up on him, okay? But nobody had talked to the complainant till I brought her to court, despite numerous opportunities. So I think if we're going to do stuff like that, I want the complainant's input, okay? Obviously, if the DA looks at me and they say, you're the prosecutor, if the DA looks at me and says,
State moves the bond forward.
Judge, I talked to this complainant. She wants a mow-up. She needs a no contact. She's scared of this guy. She doesn't want him anywhere near her or her anywhere near him, whatever, vice versa. Then I think that those things are appropriate. But if they're looking at me, they say, and this is almost pro forma in Harris County, Judge, I talked to them. They don't want the no contact, but the judge, for whatever various reason, decides to enter it. I got a problem with that. And I think some of that is just the way they've always done it. But I would at least want to know that person's input. Because I think without that person's input, now, if they say, Judge, we've tried, phone's disconnected, or we're going to send an investigator, I don't know. We'll talk about it then. But one of my most important factors in deciding whether or not you do that emergency order protection or a no contact would be, what is the person that's at the nexus of this? The person that's dealing with the situation, what do they want?
Do you think that you're going to have the skin and the toughness to be a judge? And why?
I think so, right?
I think so. Because you're going to take heat, man. If you're going to sign nollies.
Bro, I'm going to take heat tomorrow, I'm sure.
I'm going to take heat tomorrow, man.
Yeah.
I'm going to get pulled in.
I think I do. I've never been in that position, so I can't 100% answer that, right? But
well, you can't please everybody. You're going to make enemies, possibly on both sides. Based on your rulings, based upon what you do. I don't know that there is. Let's face it. You've become a politician at this point.
To some degree, yeah. I guess I already am in the game, right?
Yeah.
I filed December 11th, so there you go.
Yeah. So I just wonder from a perspective of, having been someone who's in the criminal defense family, so to speak,
right,
for a while and getting the support of everybody, are you prepared that if you make a ruling that doesn't go your way, that people start saying bad things about you, people that may have one time been your friends or, purported to be your friends anyway?
I've been doing this for almost 10 years now. I've heard plenty of things people have said about me that haven't made me happy, right? I've heard plenty of things that clients might have said about me that didn't make me happy. I'm still here. If it was easy, it wouldn't be worth doing, right?
What do you think? You talked about what you've seen down at the courthouse and,
yes, sir,
and those types of things that have been the impetus for you to be a judge. But what is it inside you that made you decide, you know what, I'm going to file for this and I'm going to do this? What was it that drove you there?
I think the biggest thing is just that I think more change can be done in that position than the position I'm currently in. I care about people, care about my clients. I don't look at them as just a way to pay my bills, right? Obviously, I like my bills getting paid, but at the end of the day, one of the reasons I do this job is also trial work, but it's more especially that I get to help and deal with real people every day, right? And some of those people are in their worst positions they've probably ever been in.
Right.
Talked to a client today that's going through some stuff, and just me talking to her, she was very much upset about some stuff she has going on in her life and some family issues that I've been through similar issues, that just talking to her she was kind of calmed down, right? And I'll probably talk to her tomorrow, and I hope she's in a better place tomorrow. But I think that if given the chance to be a judge, that I think I could reach a lot more people as far as trying to hopefully be some positive change and some positive influence, okay? Obviously, I'm younger than probably a lot of the defendants that might come in front of me, but there's also going to be a lot of younger ones, right? Hopefully you can catch some of those people, they're 17, 18 years old, and show them that there are different paths they can take, then keep coming down to that building.
You know who really does that, in my opinion, is Judge Stanley.
Yeah?
A lot of people have their own opinion on how Judge Stanley runs his court, but I'll tell you,
He cares.
he cares.
I agree.
And it's refreshing to see it, because he's been on the bench for I don't know, 20 years or 16 years. It's been a long time, and he is one that he cares.
I think what he probably catches more flack for is he does it in a different way, right? Because he's a really interesting guy, and he's not a cookie cutter type of guy. I hope I'm not. I mean, look at this face, right? Like, I'm not cookie cutter. I think he cares, and I think his heart's in the right place. And some of them I think are that way, and some of them I think have issues with that. And I hope that my heart's in the right place. I guess, if everything, the stars align and November goes well for me, then we'll have this conversation next year. You could tell me if my heart's in the right spot or not.
And Judge Derbyshire, we want you on the show. I think we're about out of time, huh?
Well, we got a minute left. So in the minute we got left, what? I was ready to cut it off. What do you think is the greatest strength you're going to bring to the bench?
Oh man, you asked me a hard question with a minute left.
You got 30 seconds.
I got 30 seconds.
Yeah.
I think that I care, and I think that I have some personal issues that help give me a little bit more compassion than somebody that has maybe had things come easier to them through life. I haven't been through some of the issues that some of our clients have, but I think that I have a little bit different perspective than some of our current judges, and I think that that can help play out and do different things in their lives.
That's all the time we got.
Thank you.
What do you?
Really good.
Are you ready to get out of here now?
Yes.
I kicked it off too early. See, that's why I'm the co-host.
Learn your role, man.
I know,
Learn your
man.
role.
I know.
This is intimidating, guys. You do this every week. It's a little intimidating.
It's not intimidating at all. Next week, we got Judge Carahan. We'll finally have our first sitting county court judge. We had Judge Hart on last year, so now we'll get our first county criminal court at law judge next week. Judge Jay Carahan will join us. But for Andrew Wright, thank you very much for joining us this week.
Thank you, gentlemen. I'll be watching next week.
Yeah, absolutely. Good luck in March in the primary, and good luck in November. For Julio Vela, I'm Jimmy Ardwan. Good night, ladies and gentlemen. We'll see you next week.
All right. Thanks, guys.